All right. If you thought the American Bar Association, the organization that sets the ethical standards for every lawyer in this country, could answer one simple yes or no question about the law, what you're about to see will genuinely shake you. Congressman Brandon Gill asked their representative something a first-year law student could answer in 4 seconds. Should race be a factor in law school admissions? She wouldn't answer it. Not once, not twice. After 7 attempts, still no answer. And that's not a coincidence. That's a strategy. Let's get into what happened, and I'll give you my full take at the end.
Mr. Jack from Georgia.
Well, thank you, Mr. Chairman. I appreciate you convening this task force today. And I myself, as well as many of my constituents who are watching, reached out to let me know how impressed they were with your line of questioning. So with that having been said, I'd like to yield the remainder of my time to our distinguished chairman, Mr. Gill.
Well, thank you. I appreciate that. Ms. Binkley, let's pick up where we left off before. The mission statement on the ABA's website states that our legal profession is enhanced when judges resemble the cultural groups that make up American society. How many Supreme Court justices have we had in American history?
I could not tell you over the
It's about 116. Do you know of those 116, how many of them have been transgender?
I have no idea.
Do you think there might have been one?
I have no idea.
Is it fair to say that there have been no transgender Supreme Court justices in American history?
I honestly have no idea.
You don't know?
I have no idea.
You study the law, don't you?
We do not study the personal attributes of individual justices.
Is there a Supreme Court justice in American history that you think might have been transgender?
I have no idea.
You have no idea? Well, I think most people can assume that there haven't been any transgender Supreme Court justices. I hope that we can agree at least on that basis. Would that be okay to proceed under that assumption? Okay. I appreciate that. So transgenders haven't been represented on the Supreme Court. Do you think that it's important that the next Supreme Court justice be transgender?
The ABA does not subscribe to any particular quotas.
I'm not asking about a quota. I'm asking about representation, diversity, equity, and inclusion.
The ABA supports diversity in all of its forms. And
have transgenders been included on the U.S. Supreme Court?
The ABA supports the full spectrum of diversity.
Do you think that it's a problem that the transgender community has never had representation on the U.S. Supreme Court?
The ABA believes in diversity, equity, and inclusion as—
And I'm asking you about diversity, equity, and inclusion. I'm asking you about inclusion of the transgender community.
We believe that people ought to bring their entire self to whatever role they're serving.
You're refusing to answer my question. Do you think that it's important that we have a transgender Supreme Court justice?
I believe that it's
in order to include that community.
I believe that it is always important, the ABA believes that it is always important to support and encourage diversity.
So we should have a transgender Supreme Court justice?
Diversity has many forms, and we believe that—
Do you think that you're not answering in a straightforward way? Do you think that's because of your own implicit bias?
I believe that I'm trying to explain that the ABA does not set quotas and does not believe—
Do you have implicit transphobia?
The ABA believes that diversity in all of its forms is important and helps the profession more globally.
Okay, we're going to move on. Should Americans be judged by the color of their skin or the content of their character?
Discrimination is never appropriate, sir.
So do you agree that Americans should be judged by the content of their character and not by the color of their skin?
Yes, I would agree.
You agree with that? Should a law school consider an applicant's race when making admissions decisions?
The Supreme Court has indicated that—
I'm asking you if they should. It's a normative question.
Discrimination is never appropriate, and—
So is it your testimony that law schools should not consider applicants' race when making admissions decisions?
The Supreme Court has said that you may not take race into account.
So you don't believe that race should have any role, yes or no, in a law school's admissions decisions? Is that the position of the ABA?
The ABA is not responsible for admissions.
I didn't say it was. I'm asking you if you believe, and if it's the position of the ABA, that race should not be a factor at all in a law school's admissions decisions?
The ABA takes compliance with the law seriously.
I didn't ask you that. I asked, it's a really simple question. I'm asking you, let me just ask you in your own personal capacity, should race be a factor in law school admissions decisions? The question is a yes or no question.
I am here in my
Yes or no,
capacity.
should race be a factor in law school admissions
I
decisions?
am here in my capacity.
Because according to the ABA, it should. The ABA has said explicitly that they have a long history of supporting consideration of race in law school admissions. Is that your testimony, that law schools should continue taking into account race?
The Supreme Court indicated that diversity is a laudable goal, and the ABA supports diversity in all of its
This is
forms.
embarrassing for you. You ought to be able to answer this in a very straightforward way. And with that, the time is up.
Sir, I have three UCs requests.
Go for it.
Thank you. I ask unanimous consent to enter into the record a July 2026 article from Kerner News, North Texas families and the summer food programs they rely
Without
on
objection.
are feeling the sting of inflation.
Without objection. All right, and we're going to skip closing because we've got votes now. So in closing,
Okay, let me just validate the feeling you probably had while watching that. Because on the surface, it looks like a congressman scoring cheap political points off a bureaucrat who couldn't keep up. But if you slow down and actually look at what happened in that room, this is one of the most revealing things I have seen in a congressional hearing in a long time. And I do not say that lightly. So let me walk you through it piece by piece, because every layer of this matters. Let's start with who the ABA actually is, because I think a lot of people see that acronym and think, okay, some legal group, whatever. No, the American Bar Association is the single most powerful legal organization in the United States. They set the accreditation standards for every law school in this country. They write the ethical rules that govern every licensed attorney. They have a formal role in evaluating federal judicial nominees. When the ABA rates a judge as not qualified, that rating follows that judge for the rest of their career. So when they send a representative to testify before Congress, the absolute minimum expectation, the floor, not the ceiling, is that she can answer a direct question about the law. That is what they do for a living. And what I watched in that clip was a representative of that organization failing to clear the floor. Now, let me tell you what Gill was actually doing, because his strategy had a very specific structure, and once you see it, the whole hearing makes sense. He started with the transgender question. And look, I want to be honest with you. At first glance, that section feels like a political trap. It is, but it's not a pointless one. Gill was not genuinely asking whether the next Supreme Court justice should be transgender. He was running a test. He was calibrating the witness before he got to the question he actually cared about. He asked how many Supreme Court justices there have been in American history. About 116. He asked how many were transgender. Almost certainly none. Simple question, right? And instead of just saying that, the representative said, and I went back and watched this 3 times to make sure I had it right, I have no idea. 7 times. Not once. Not twice. 7 times she said she had no idea whether any Supreme Court justice in American history had ever been transgender. Now think about what that actually means. You represent the organization that trains, licenses, and sets the ethical standards for American lawyers, and you cannot say, with reasonable confidence, that no transgender person has ever sat on the United States Supreme Court. That is not ignorance. That is a decision. She made a calculated choice in real time that no answer was safer than any answer, and Gill knew it. He was documenting on camera that this witness was going to dodge every question that could be clipped and used against the ABA's political positioning. That's what he calls the tell. And once you see the tell, the rest of the hearing is almost predictable. Because then he pivoted to the real question. Should race be a factor in law school admissions? Now I want to stop here and explain why this question is not complicated, because the Supreme Court already answered it. In June 2023, in Students for Fair Admissions versus Harvard and the University of North Carolina, the Supreme Court ruled that race-conscious admissions programs violate the Equal Protection Clause of the 14th Amendment. I went and read the majority opinion. Chief Justice Roberts was not subtle about it. He wrote, and I'm paraphrasing here, that a student must be treated based on his or her experiences as an individual, not on the basis of race. That is the law of the land. It is not a gray area. It is not pending further litigation. It is a settled Supreme Court ruling. So when Gill asked the ABA representative whether race should be a factor in law school admissions, he was not asking a controversial philosophical question. He was asking her to affirm what the Supreme Court already decided. And she still would not do it. Instead, she retreated into the language of diversity. The ABA supports diversity in all of its forms. We believe people ought to bring their entire self to whatever role they're serving. The Supreme Court has indicated that diversity is a laudable goal. I've been thinking about those responses since I watched this clip, and here's what genuinely gets me. The ABA, the organization that teaches lawyers to be precise, to say exactly what they mean, to ask clear questions and give clear answers, deployed the most deliberately vague, evasive, meaningless language imaginable when asked a direct legal question. That is not an accident. That is institutional self-protection dressed up as thoughtfulness. And here's why that matters beyond the politics of affirmative action. If the representative said yes, race should still be a factor, she is publicly contradicting the Supreme Court on camera. That is a legal liability and a media nightmare. If she said no, race should not be a factor, she alienates a significant portion of the ABA's membership that has spent decades fighting for race-conscious admissions. That is a political liability and a fundraising nightmare. So she chose the third option. She said nothing, wrapped in the language of everything. And look, I understand the bind, I genuinely do. These are real institutional pressures, and pretending they don't exist would be naive. But here's the problem. The ABA's own mission statement, the one Gill read directly from their website, says the legal profession is enhanced when judges resemble the cultural groups that make up American society. That is a public commitment. It is a normative claim, sitting on their homepage, for anyone to read. And if you are willing to put that claim on your website, you should be willing to defend it when someone asks you about it under oath. The moment you refuse to do that, you have revealed something important about the nature of that commitment. It holds when it is comfortable. It disappears when it costs you something. And that, to me, is the real scandal here. Not where you land on affirmative action. Reasonable people disagree on that, and I'm not here to tell you what to think about it. The scandal is that the institution charged with upholding legal ethics performed, in front of Congress and on camera, exactly the kind of evasion it trains lawyers to identify and dismantle in hostile witnesses. Gill called it embarrassing. He was right. But I think the more precise word is revealing, because here is what this hearing actually revealed about how large institutions behave when they testify before Congress. They do not come to inform the public. They come to protect the brand. They are coached before every hearing to deflect, to redirect to legal precedent, to use their mission statement as a shield rather than as a commitment. And they count on most hearings being boring enough that nobody is really watching. Imagine if you or I were called to testify before Congress. If someone asked us a direct yes or no question about the rules of our own profession, and we responded 7 times with, "I have no idea," we wouldn't get a polite, "Time's up." We'd get a contempt referral and a very expensive attorney. But because this is institutional testimony, because the ABA has 100 years of credibility behind it, the evasion gets dressed up as nuance and the hearing moves on. That double standard is worth sitting with for a second. Now let me zoom out, because there is a systemic point here that goes well beyond this specific hearing, and I think it's the most important thing I want to leave you with. When institutions that are supposed to model legal clarity and ethical courage refuse to give honest answers to direct legal questions, they send a signal to the entire profession. They signal that strategic ambiguity is acceptable, that protecting institutional reputation matters more than public honesty, that you can invoke the language of values without ever being accountable to them. And that signal does not stay in the hearing room. It trickles down to the law students who will become the prosecutors and judges of the next generation. The ABA does not just publish ethical rules. The way it behaves when challenged, not on paper but in real time under questioning, is itself a form of instruction. And what it demonstrated in that room was a masterclass in how to appear cooperative while saying absolutely nothing. Here is what I think you can take away from this. A legal system that cannot produce honest answers to direct questions about its own policies is not a system that builds public trust. It is a system that earns public suspicion. And the distance between institutional evasion and institutional corruption is a lot shorter than most people are comfortable admitting. So the question I keep coming back to is this. If the organization that writes the rules for legal ethics cannot model straightforward honesty when it matters most, when the cameras are on and the oath has been administered, then who exactly is going to hold the legal profession accountable? If you want to keep watching hearings like this one broken down the way I just did, subscribe to this channel, because these are the moments that tell you more about how power actually works than any policy paper ever will. And if we stop paying attention, institutions will keep answering every hard question the same way, with nothing, wrapped in the language of everything.